If parties disagree about an ambiguous contract term or a term with more than one possible meaning, courts are often called upon for interpretation. But in Colfax Envelope Corporation versus Local Number 458 3M, we explore whether some misunderstandings about meaning are so fundamental that rescission, or contract abandonment without liability, is the appropriate remedy. Colfax Envelope Corporation owned 2 printing presses, operated by employees belonging to a union. Colfax didn't participate in collective bargaining between the union and the Chicago Lithographers Association, which represented other printing companies. Instead, after reaching a new agreement, the union would send Colfax a copy, and Colfax would either execute the agreement or negotiate with the union independently. Under an existing agreement, Colfax was required to man both of its 78-inch presses with 4 men. In 1991, the union and the association negotiated a new agreement, and Colfax received a summary of the changes. With regard to manning requirements, the summary listed, quote, 4C 60-inch press, 3 men, unquote. Colfax interpreted that to mean that presses 60 inches or wider, such as Colfax's, only needed 3 men. Finding the terms advantageous, Colfax signed the summary, agreeing to the terms, read in conjunction with the collective bargaining agreement they modified, which included an arbitration clause. The union later distributed a revised agreement, clarifying that the 3-man requirement only applied to presses 60 inches and narrower. When Colfax refused to sign the revised agreement, the union claimed that Colfax was already bound by the term, because Colfax accepted the summary. Colfax filed suit, seeking a declaration that there was no enforceable collective bargaining agreement because there was no meeting of the minds as to the manning requirements, an essential term. The union counterclaimed and sought summary judgment to compel arbitration. The district court ordered arbitration, finding the bargaining agreement, and consequently its arbitration clause, enforceable. Colfax appealed to the 7th Circuit.